great leader working for the welfare of legal fraternity and representative for more than 2 lakh lawyers. We extend our warm welcome to our honorable judges and thank them for their valuable time and graceful presence for elevating the level of semi-final round.
Thank you, everyone. And we can, I think, commence with the competition subject to Vinay.
Yes. Thank you, sir. Now I would like to introduce the introduction section for participants. Each team will get 30 minutes for the oral submission. The time division for the council must be informed to the court before proceeding. Rebuttal must be requested for the bench to commencement of the argument. Now I please the court, I please the bench to give permission for the petition to argue.
Please go ahead.
Warm greetings to the bench. I will seek permission of the bench to collectively call bench as your lordships. I'll seek bench permission to briefly state the facts, your lordship.
Please do.
Banki Bihari temple located in Vrindavan, Uttar Pradesh is one of the most important Krishna temples in India and major site of pilgrimage, which attracts 50 lakhs pilgrimage annually, with the numbers swelling dramatically during the religious festivals such as Janmashtami, Holi and Kartik Purnima. So this temple is situated in a organically developed heritage precinct characterized by traditional residential structures, century-old religious institution and small-scale commercial establishments. So despite multiple studies, administrative observation noting the area's vulnerability to congestion, comprehensive infrastructure changes had not been implemented prior to 2022. On 19th August 2022, during the celebration of Janmashtami, a tragic stampede occurred during the early morning Mangalarti, one of the most sacred and crowded rituals at the temple. The incident resulted in the deaths of 2 devotees and caused injuries to at least 25 others. Initial reports attributed the tragedy to the combination of factors like lack of regulated entry and exit points, insufficient personnel of crowd control, and physical constraints. Aftermath, civil society groups approached the High Court, Allahabad High Court under PIL under Article 226, seeking a judicial intervention and prayed for development of comprehensive crowd management system, emergency medical infrastructure, and widening the access to the roads. So High Court acknowledged and directed the government to implement the Banke Bihari temple, which in response to the High Court petition which the government proposed. So the plan involved demolition of 300 structure, acquisition of approximately 8 acres of land, and construction of dedicated corridor emergency exits. On 20th March 2023, Allahabad directed the state to implement the project without any delay. So after the High Court judgment, coalition groups led by the Govindas filed special petition in Supreme Court of India and argued that this result in a forced eviction of 200 families, displacement of approximately 500 small business, and irreversible damage to the cultural fabric of Vrindavan. So he contended that the violation of Environmental Acts, Archaeological Sites Act, and EIA provisions, and the state government defending the corridor submitted that the project was critical public safety measure and 300 crores had already been spent and on land acquisition. So Govindas and other stakeholders filed a modification application urging the court to prevent even the land acquisition until the due process was followed. So recognizing this complex interrelationship between right to religion, right to life and environment, protection of property, the state's environmental and cultural duties, Supreme Court referred the matter to 5-judge constitutional bench. A high-powered committee was also constituted. If my lordships are well versed with the facts, I'll request the bench permission to move on to the arguments, your lordship.
Yeah, please do.
Your lordship, there are 4 issues which was given for the consideration. So first 2 issue, I'm dealing with the first 2 issues, and my co-counsel will deal with the other 2 issues. So what is that first issue? That is whether the High Court's mandamus under Article 226, directing a particular scheme, amounts to an impermissible micromanagement of executive policy or is a constitutionally valid exercise to remedy. So to understand this, to determine whether it is a constitutionally valid interference or it is a micromanagement of policy, we should first understand the doctrine of separation. So to understand the doctrine of separation, we should go trace back to the Greek era, where the first this principle was mentioned by Aristotle in the book Politics. He explains that these doctrine of separation of power, while he was explaining what are the features of the model state, he explains that one of the essential of that model state is this principle of separation of power. That means power should not be concentrated in any one organ of the government, but that power should be distributed upon the different arguments of the government, that is legislative, executive, and judiciary. Further, Montesquieu develops this doctrine and he connects liberty with the separation of power. He says that this liberty of the people only can be ensured when there is a separation of power, and not the power is not concentrated in any one hand or one person or any one organ of the government. He explains that this liberty will end when one organ of the government, either judiciary or executive, try to encroach into the another organ's duty, and or the when one organ tries to step into the shoes of another organ, then it will be the end of people's liberty or lordship. So when come to India, in India, this separation of doctrine of separation of power is not purely incorporated, but it is incorporated under Article 50. Article 50 says that the state shall take steps to separate the judiciary from executive in the public services of the state. So here our founding fathers emphasized on the fact that judiciary should be separated. A state shall take steps to separate judiciary and executive. So now it is, so we should determine that where is the thin line exists between the judiciary and the executive, where one should not encroach upon the fields. So in the case of Golaknath versus State of Punjab, where there was a battle between the executive and the judiciary over the land reforms matters, Supreme Court held that the government organs of the governments are expected to exercise their function within their limits. So if the limits are crossed, then it will be the violation of doctrine of separation of power, which is the basic structure of our constitution. In Almatira H. Patel versus Union of India, in this case also facts were like this. It was the duty of the Delhi Municipal Corporation to clean the city. So it was the duty of the executive. So petitions were filed in the Supreme Court asking the Supreme Court to direct that Delhi Executive Municipal to clean the city. But court applied the principle of judicial restraint, and it itself restrained from encroaching into the executive matter, and held that so cleaning the Delhi is of the executive domain and court cannot interfere in that. Even in our case, to connect to our case also, it is the duty of the state to provide infrastructure. So even though it is the duty of the infrastructure, to similar to the this case, court cannot step into the executive domain questions to direct the state. In the case of West Virginia versus Environmental Protection Agency, in this case, major questions doctrine was evolved. It was held that whenever it is a major questions, it to be determined by the legislative and executive, it should not be touched by the judiciary. So it is said that once it is established that it is a major question, it should not be interfered by the judiciary. So if we apply the same major question test to our case, so this is one of the important infrastructure and economic policy, and it is a major question which should not be touched by the judiciary. In the case of Balco Employees Union versus Union of India, in this case that where the people approach the Supreme Court telling that the Supreme Court should interfere in the economic policy. Court held that infrastructure policies are like economic policies. In those cases, judiciary cannot directly intervene. Only place where judiciary can intervene is that judiciary can ensure that such economic policies are implemented without any violation of fundamental rights and followed due process is followed. So to apply this doctrine to our case, two tests should be passed. First, we have to determine whether this building a corridor is an economic policy or not. So if we examine, as this infrastructure policy is highly connected with the tourism, employment, and other economical things, it is a purely economic policy. So first question is resolved that this corridor infrastructure project is economic policy. So as it is economic policy, as in this case held that economic policies cannot be evaluated and its merits cannot be evaluated by the court. So as the court held, only what court can do, what court can interfere is that court should ensure that such economic and infrastructure policies are implemented with a due process followed and without any fundamental rights violation. And the landmark case in this regards. So when can judiciary interfere? A Narmada Bachao Andolan versus Union of India, where court held that court cannot interfere in the executive policy questions. So here, to pertaining to our issue, when can it can be determined as a valid judicial intervention and when it amounts to micromanagement of policy. In this case, court can explain when can a court interfere in a infrastructure policies. So court explained that it's clearly explained in what stage if court interferes it will be a valid judicial intervention. So there will be three steps in any infrastructure policy. The first step is planning to that infrastructure project. Second, taking the decision to implement that project. Third is the execution. Supreme Court in Narmada Bachao case explained that the first step, that is taking a planning for the project, it is a executive policy, it is up to the legislature. And the second, that is ensuring that taking the decision after the due process is followed. Court held that if the court interfere in the first and the third stage, that is planning for the infrastructure project and execution of project, if that places court interferes, then it will be a micromanagement of economic policy. Then where can court intervene? Supreme Court explained that court can intervene in the second stage, that is taking the decision to implement the project after the due process is followed. So court can intervene in the second stage, that is taking a decision after the due process is followed. So court can intervene there and ensure that due process is followed before taking the decision. But in the present case, the planning stage is already done. Planning for the corridor project is already done. So High Court, without going to the second stage, that is due process for the taking the decision, it skipped the second stage and directly it jumped to the third stage, that is execution of the policy. So court skipping the second stage of due process, it directly skipped to the third step, that is execution of the policy, and directed the state to execute the
What do you
policy,
mean by
which
due
will be the
process?
violation.
What do you understand by due
Your
process?
Your Lordship, due
What
process
is
means,
meant by it?
due process means, Your Lordship, state action should be a fairness procedure should be followed, Your Lordship. A concerned party should be heard, Your Lordship.
No, let me just little moderate the question which Mr. Sondhi has put into you. What are the contours of the court's interference? On what basis court can interfere at stage 2?
Your
What
Lordship,
are the grounds on which court can examine and court can interfere?
indeed, Your Lordship.
Yeah.
As in Narmada case, it was held that in a second stage, after the planning, state will take the decision to implement that project. So court can intervene on the ground that whether the due process or the, as sir asked, what is due process, whether the people who will be affected by the project, whether they are consulted or not, whether their grievance are heard or not. On that basis, if their right to heard or if their grievances are not heard, if the process is not followed, then if the state has taken the decision without following the process, without hearing the grievances, on that ground court can interfere, Your Lordship.
So if supposingly it is a matter of policy which the state has evolved, do you mean to suggest that the court has no power to interfere at any stage of policy making, or court can interfere at some stages of policy making?
Your
And
Lordship,
are you aware of a principle called Wednesbury principle, which is applied in judicial review?
Indeed, Your Lordship.
Yes.
Your Lordship, argument doesn't mean that court cannot interfere at any stage. My argument is that court can interfere at the stage where the decision is taken, Your Lordship. In a policy decision, court can interfere when the fundamental rights are violated and when the people's grievances are not heard, Your Lordship. In India, the separation of power is not strictly incorporated. Judiciary can intervene in the policy matters when there is a violation of fundamental rights, when the decision is taken without following the procedure, Your Lordship, when there is no fairness in the decision, Your Lordship.
Well,
Please go ahead.
Indeed, Your Lordship, in the present case also, High Court in his judgment directing a particular corridor project did not going for the due process or the taking the consultation of the people without at the stage of decision making, directly skipped to the third stage, that is execution stage, and directed the stage to implement a particular project, your lordship. That violated the principle of separation of power, your lordship. In the case of Asif Muhammad versus Jammu Kashmir, Supreme Court held that high courts can intervene in administrative actions and executive actions only when there is a violation of fundamental rights, only when there is not fairness and reasonableness in your lordship. If your lordships are convinced with the first issue, I'll request permission to move on to the second issue, lordship.
Before you move, paragraph 7 of the moot court proposition,
Indeed, lordship.
towards the bottom, that the petitioner has alleged that no proper public consultation had been conducted.
Indeed, your lordship.
Talking about due process, you said that it was not conducted at all.
Indeed, your lordship.
So, as per it, the public consultation was conducted.
Your lordship, in court in different cases held that consultation should be proper, your lordship. It should be taken consideration of all people who are affected, your lordship. The grievance should be, and tests like SIA, social impact assessment, environment assessment, those sets should be held and considered, your lordship.
Have you pleaded anywhere that a representation was made or some kind of meeting took place with the members of the community at large? Is it mentioned anywhere in your submission?
Your lordship, but the Govindas had led these groups after their grievances. It is mentioned in the proposal, your lordship.
Please come to the second issue.
The second issue is whether the reconfiguration of temple approaches, alleys, and religious circulation routes implicates Article 25 and 26, and if so, the correct test to distinguish faithful facilitation from the unconstitutional interference. So, to understand this, first we should understand what is the religion in India. Swami Vivekananda explains in India, Hindu religion not only includes the intellectual assent to the scriptures, but it also includes the wisdom, rituals, and practices of the religion, your lordship. In the preamble of the constitution, our constitution gives for the freedom to practice, profess, and propagate their faith. In the preamble, it is mentioned that India is a secular country. It doesn't mean that it is not in a negative sense, but in a positive sense that every individual get their freedom to practice, profess. So emphasis should be added to the word practice and profess, your lordship. In the Article 25, it is mentioned that subject to the public order, morality, health, and other constitutional provisions, all persons equally entitled to freedom of conscience and the right to freely profess, practice, and propagate their religion, your lordship. So the emphasis should be added to the words freely profess, practice, and propagate their religion. So here the constitutional protection is not only available for your belief, but the constitutional protection is also available to profess and practice your religion, your lordship. So Ranjan Goyal explains what is the Hinduism and at what context this protection of the constitution will be get. So he explains that in Hinduism, antiquity and tradition plays a pivotal role. So when Hinduism, the traditions are time antiquity, so they place more emphasis on the antiquity and tradition, your lordship. So if they're deviated from that tradition or tradition which is followed by the time antiquity, then it may cause the revolt, your lordship. In the case of SP Metal versus Union of India, court held that state must not interfere in the practice unless it is shown as essential religion, your lordship. Once it is shown that it is essential religion, state cannot interfere in such matters, your lordship. In the case of
no, but you tell me only one thing. How does creation of a corridor for approach or for access to the temple, how does it interfere with the religious practices or the guarantee under Article 25?
Your lordship.
What is your argument on
that? Your lordship. Yes, sir. Yes, indeed, your lordship. I am arguing on that point. So, court explained to the line where state can interfere and where state cannot interfere. To explain that, Supreme Court have evolved a test called essential religious practice test. So, this test says that whenever such practice and rituals are proved that it is the essence of the religion, state should not interfere in such religion, your lordship. So, the next question that arises in our mind that who is the authority to decide what is essential to religion and not what is essential to religion? In the landmark case about where state can interfere and where state cannot interfere, in the case of Commissioner Hindu Religious Endowments Madras and Sri Lakshmi Tirtha Swamiyar of Shirur Mutt, the famously known as Shirur case. In this case, court held that the constitution protection not only expands the religious opinion, but it also expands to the pursuance of religion, Your Lordship.
Just hold on, Mr. Counsel. What's your good name, please?
Your Lordship, Pawan Kalyan.
Mr. Pawan. Mr. Pawan, you just tell me, how does the question of interference with religious practices or the right to exercise religious practices or a right under Article 25 arise in this case? See, before you make an argument or before you challenge, see, you have to keep one thing in mind as to what is your challenge. And what do you want to achieve? What do you want the court to say? Do you want the court to say that this is not my religious practice, or this is my religious practice, and since it is my religious practice, so there should not be a corridor, or there should be a corridor? Right? How is creation of a corridor related or interlinked with your right to exercise your religion?
Indeed, Your Lordship. In
Yes.
this case, state proposed a corridor project. So to determine whether state can interfere or not, we should first determine whether going to that temple, to that sacred precinct, whether it constitutes an essential practice or not. So in this
Forget about it. You take that temple to be a railway station.
Indeed, Your Lordship.
And court directs that there is a very narrow approach to the railway station. Every day there are accidents happening.
Indeed, Your Lordship.
Correct. Somebody comes with a PIL saying that there should be a proper way and there should be a wide road for approach to the railway station, because large number of people approach the railway station. And court entertains that petition, entertains that PIL, and says that yes, it is in public interest and the state must act on it. And since the state is not acting, so we are directing that you evolve a procedure or you evolve a policy whereby you have a wider approach road for the railway station. So for the time being, for the argument of this case, you take this Banke Bihari temple to be a railway station. Right. Now, this corridor is to facilitate approach, or it has any other meaning also? Legally, it is to facilitate approach. So, when you are to facilitate approach only, then whether you, after entering into the temple, you just go and sit there, or whether you actually do your worship, prayers, etc. or not, that is not the issue. Issue is to approach the temple. Right? So, as I told you, you take a hypothetical example of a railway station where large number of people gather, they approach. So so if you take it as a railway station, then your argument under Article 25 is not available and applicable. So then essentially you are on the exercise of the executive power. And you are on the exercise of the power of the High Court under 226 to direct the executive. Correct? To create a corridor or not to create a corridor. Yes. So now you argue confined to that line.
Your Lordship, as to answer to the first question, my co-counsel will argue whether the alternatives will suffice for that for this corridor, Your Lordship. There are existing alternatives are there for Your Lordship. So you given a hypothetical example of railway station, Your Lordship. When we approach a railway station, Your Lordship, it is not a practice of religion, Your Lordship, for which protection under Article 25 can extend, Your Lordship. But
21 is there.
Your Lordship, to facilitate that approach to the railway station, 21 is there, Your Lordship. But
yes.
in approaching the temple, while facilitating the temple under Article 21, we should not infringe Article 25, that is right to religion, Your Lordship. Now I'll argue how 25 will be violated, Your Lordship, by implementing the corridor. In this case, Shirur case court explained that for what extent did constitutional protection under right to religion extends. So court explained that it is not merely for the religious opinion, it also extends to the acts done in the pursuance of religion, Your Lordship. So the emphasis should be added to that the constitutional protection will be extended to the acts done in the pursuance of religion. So going to the temple, approaching the temple to this valley, which has a religious institution beside that. So there may be a traditions like first you should visit this temple, and you should visit the main temple. There may be such practices. So even though those acts like going to darshan through this sacred alleys, it is clearly mentioned in the it is organically evolved and it is sacred. So approaching the temple through this sacred and organically evolved to that. So this act of going to darshan, this is the act which is done in the pursuance of religion, your lordship. So as established in the Shirur Mutt case, so the constitution protection should be given to the not only the religion, to the also to the act done in the pursuance of religion, your lordship. So these acts done in the pursuance of religion, it also constitute the essential part of the religion, your lordship. So as this darshan is the act which is done in the pursuance of religion, so it constitutes the essential part of the religion and it should not be touched, your lordship. So then, as I already mentioned, the question arises, who is the authority to decide what is essential to religion and what is not essential to religion? In the case of Sheshammal others versus Tamil Nadu, in this case, court held that it is not the judiciary, it is not the state to decide what is essential to religion, because they are the secular organs of the government. But it should be the community or the followers of the religion who is the authority to decide what is essential to religion, your lordship. So the right to decide what is essential to religion is upon the devotees and the followers of the religion, your lordship. So in the present case, so large part of the community believes that going to that darshan and approaching the temple through that sacred precinct, which is organically evolved, is a part of this essential part of the religion. So as it is, they are the authority to decide what is essential to religion. So the protection under this article should be extended to the act done in the pursuance of that approach, your lordship. In the case
Mr.
of
Pawan, you have already consumed 29 minutes.
last 1 minute, your lordship. Last 1 minute.
Yes. I think you have not left any time for your other speaker, for the petitioner.
Your lordship, I'll seek permission. Just 1 minute, your lordship. Then I'll.
Yes, 1 minute, and with consent of all others, Mr. Sondhi, can we give him 5 minutes for the second speaker?
Sir, I think, sir, we can allow, sir.
Yeah.
We have too many questions. We can allow, sir.
Yes.
In the case of Ratilal Pranchand versus Gandhi versus State of Bombay, it is also held that so this protection under Article 25 also extends to the acts performed in the furtherance of those beliefs.
So you take these decisions as read. You tell me the proposition.
Indeed, your lordship, as mentioned in the proposition, it is a sacred precedent, and approaching that precedent it constitutes an essential part of religion. It should be protected, your lordship. Now, next, whether the alternatives will suffice, that issues will be dealt by.
Yes. Now, only one word of caution to all of you, for appearing for petitioner and as well as for the other side. Please do not read all the judgments. You just name the judgment and say one word about it, that on what point you want. You want it for separation of power, you want it for judicial review, you want it for anything else. Beyond that, don't spend your time on reading the judgment. You confine yourself to the legal proposition which you are making. All right? That will save your time. All right. Yes, ma'am.
Indeed, your lordship.
Yes.
Issue 3 is whether the state's objective of crowd management and public safety under Article 21 justifies the large-scale demolition and redesign of an organically evolved sacred prison when less restrictive alternative measures are available. Your lordship, the Banke Bihari temple is an organically evolved heritage prison with immense religious and historical significance. The large-scale demolition and redesign of such a sacred and naturally developed prison was neither necessary nor justifiable. The same would be presented by me in my 4-4 argument. Through my first 4 argument, the petitioners would humbly submit that the stampede that occurred on August 19, 2022 was a direct consequence of the systematic failure of the state in performing its duty, your lordship, owing to regulating the crowd and owing to the absence of regulated entry and exit points and insufficiency of personnel in managing the crowd, your lordship. Instead of taking the responsibility for the same, the state has shifted the blame on the geographical features of the Banke Bihari temple and the sacred presence around it. Your lordship, I would bring to your lordship's attention to para 2 of the facts.
Don't you think that for precisely this particular reason the corridor is being established?
Indeed, your lordship, I will establish the same, your lordship. para 2 of the facts, which states that comprehensive infrastructural changes had not been implemented prior to 2022, Your Lordship, nor any crowd management system was opted by the state to ensure safe and sound darshan to the devotees, Your Lordship. The same was played before the Allahabad High Court by the civil petition by a PIL filed by the civil people before the Allahabad High Court, requesting for a development of comprehensive crowd management system, emergency medical infrastructure, widening of access roads, and creation of safe and entry exit channels, Your Lordship. I would also mention a statistics, Your Lordship, dated August 7, 2025 of the Times of India, which reveals that devotees of 50,000 who visit the temple a day, and over 1 lakh in the weekend, and annually 5 lakh devotees visit the temple, Your Lordship. Such being the case, it was the bounden duty of the state to provide crowd management facility, Your Lordship. Prior to 2022, the government did not bother to give any such crowd management facilities, Your Lordship. In the persons of which we appeared before the Allahabad High Court, Your Lordship, and also prayed for such alternative measures. Secondly, Your Lordship, I would like to establish when other alternative measures are available, it is the duty of the state to opt for the same rather than opting for a destructive project, Your Lordship. In the case of the Travancore Devasthanam Board Employees Front versus State of Kerala, here it is famously known as the Sabrimala Virtual Queue System case, Your Lordship. In this particular case, a tragic stampede which occurred on 2011, as a result of which the Kerala police opted for the virtual queue system, Your Lordship, through which the devotees are monitored through an app or an online platform and then let into the queues until when they can rest elsewhere, Your Lordship. Such being the case, the state negligently did not adopt such proper mechanisms to provide safe and sound darshan to the devotees, Your Lordship, and no proper adequate measures were provided to prevent such further tragedies, Your Lordship. And in the case of TTD Employees Association versus State of Andhra Pradesh, in this particular case, the court also said that ensuring orderly darshan is an essential part of managing the pilgrim inflow, Your Lordship. The same was not also followed by the state. And another alternative measure which was available to the state was in case of P. Venkateshwarlu versus Executive Officer Tirumala Tirupati Devasthanam. In this particular case, the time slot darshan was challenged as violative of Article 25, Your Lordship. In this particular case, the Supreme Court emphasized that Article 25 does not extend to providing to demanding darshan at a particular time, Your Lordship, but in a regulated manner. The state here could have opted for staggered darshan, tech-enabled flow, and festival time regulation, Your Lordship. When such alternative measures were available, the state opted for a bigger corridor project, which resulted in the violation of fundamental rights of the stakeholders, Your Lordship.
Ma'am, wind up faster. Your time is going. It is already 5:35. You have to wind up faster.
Indeed, Your Lordship.
Yes.
Another 5 minutes to wind up, Your Lordship. In Narmada Bachao Andolan versus Union of India, Your Lordship, the Supreme Court particularly held that when a large-scale project
That we have read, you come to the next point. Come to the next point. Yes.
Indeed, Your Lordship. The proposed redesign of an organically evolved sacred precinct, it also contravenes with the Ancient Monuments and Archaeological Sites and Remains Act 1958, Your Lordship. It is the duty of the state under Article 49, Your Lordship, to protect the monuments, places, and objects of artistic or historic interest, Your Lordship. The preamble of the Act also states that preserving ancient and historical sites and monuments, Your Lordship. Section 2A, which defines ancient monuments, which includes any structure of historical, archaeological, or artistic interest which has existed for not less than 100 years, Your Lordship. The Banki Bihari Temple also satisfies the two prerequisites, Your Lordship. The Banki Bihari Temple, which is aged 160 plus years, and secondly, that it has artistic or archaeological interest, Your Lordship. And the same protection under the Act should also extend to the Banki Bihari Temple and the sacred precincts around it, Your Lordship.
So no harm is being caused to the temple, just the corridor is being established, and there were several PILs which were filed where urgent judicial intervention was sought, and they prayed for the development of a comprehensive crowd management. So this is what state is doing, creating a corridor, and as Vinay had stated a couple of minutes back also, that if you take an example of the railway station, the crowd management, etc., that aspect still has not been addressed.
Indeed, Your Lordship. Our contention is that the Banki Bihari Temple, which also has sacred presence around it, Your Lordship, we are seeking the court's intervention in protecting those sacred institutions, Your Lordship. In the case of Rajiv Kumar Yadav versus Archaeological
So you
Survey
mean to say that the buildings around Banki Bihari Temple, they are also the sacred precincts and all that?
institutions, Your Lordship. Yes, Your Lordship. It is
And
specifically
please understand what is protected under the Act is only a protected monument,
Indeed, Your Lordship.
not the buildings around it. Supposedly there is a house around the nearby. Is it also protected under the Protected Monuments Act?
Indeed,
And
Your Lordship.
second question is, supposedly there are two alternatives and the state chooses one. Is it for the petitioner to say that no, you have to choose the second and not the first?
Indeed, Your Lordship. I would address the same. We are seeking the protection of the Act for the sacred institutions around the Banke Bihari temple, Your Lordship. These sacred institutions are protected monuments, Your Lordship.
You have not named even one.
Will further do it, Your
Yes.
Lordship. And according to the World Bank report, which states that the Radha Madan Mohan Temple and Sri Radha Ballabh Mandir, these are the protected monuments around the Banke Bihari Temple, Your Lordship. Also, according to the ASMR Act, that Section 20A states that no construction can be carried out within 100 meters of the protected monuments, Your Lordship. The protected monuments,
That's the
also
argument.
the area around it becomes a protected site, Your Lordship.
That's the argument, man, which you should have made in the first instance. Yes.
Indeed, Your Lordship, was arriving at the same. Lastly, Your
Come
Lordship.
to the last point. Come to the last point now.
Indeed, Your Lordship. Here, the state has not
Public
sought any
consultation.
particular
You have
authorities'
said public
permission to
consultation.
conduct the construction. Also, Your Lordship.
Come to the public consultation point. Last point.
Indeed, Your Lordship. Indeed, Your Lordship. Issue 4: whether the absence or inadequacy of meaningful public consultation of the stakeholders renders the decision-making process arbitrary under Article 14, Your Lordship. Article 14 of the Constitution states that state shall not deny any person equality before law or equal protection of law within the territory of India, Your Lordship. Article 14 does not only extend to inequality or discrimination, Your Lordship, but also to all state actions which are arbitrary, unfair, and unreasonable, Your Lordship. In the case of E.P. Royappa versus State of Tamil Nadu, here the petitioner's rank was reduced.
Leave the judgment. You tell what is the arbitrariness which you point out.
Indeed, Your Lordship. Here,
Yes.
the state did not consult the stakeholders nor waited for any objections to be raised, Your Lordship. And this resulted in arbitrariness, Your Lordship. Furthermore, Your Lordship, the decision here, the failure of the authorities to conduct a meaningful public consultation with the residents, the shopkeepers, the religious institutions, the environmental experts, and also archaeological conservationists was not taken into consideration, and the authorities were not sorted. Here, Lordship, the fundamental rights of the residents, their right to live, the shopkeepers whose livelihood was mainly dependent on the temple economy, Your Lordship, and the religious institutions which were protected, Your Lordship, and the environmental experts who sought that irreversible and damage could be caused to the ecology, Your Lordship.
Ecology of what? Yamuna floodplains, you are saying.
Indeed, Your Lordship.
But you have not uttered that word at all.
I would address the same, Your Lordship. Just 2 more minutes, Your Lordship. In the case, sorry, Your Lordship. In the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013, Your Lordship, prior to which 1894 Act which existed did not have public consultation, Your Lordship. For this very purpose, through a 2013 amendment, Section 5, which laid down the obligation on the state to conduct a public hearing in the affected areas and to ascertain the views of the affected families and to incorporate the same in the social impact assessment, Your Lordship. The social impact assessment is a very need, Your Lordship. It is a structured process where it identifies, analyzes, and manages the socio-economic and cultural consequences of a particular plan or project, Your Lordship. Here, Section 5 also mandates that the same report has to be published in an official gazette, Your Lordship. Here, the state has also not followed the same. And also, Your Lordship, in the case Environment Impact Assessment Notification of 2006 under Section 3 of the Environment Protection Act, which mandates that prior environmental clearance for any new or expanded projects is need to be sorted, Your Lordship. Here, in the case of AP Pollution Control Board versus MV Naidu, in this particular case, the court held that environmental impact assessment cannot be bypassed even in urgent matters.
Done. Okay.
Here,
Let
the
the other side begin. Okay, thank you. You have done very good. You have done very good. Yes, ma'am. You are on the other side.
Now, with the permission of bench, I would like to request counsels for respondent to kindly proceed for the argument before the court.
Before you proceed for the respondent, one word of caution. Please do not waste your time in reading the judgments. As I suggested, you just refer the name of the judgment and the proposition on which you are pointing out. All right. Save your time. Confine yourself to the legal proposition. Correct? Now you start, please.
Greetings to the bench. My lord, I
Yes.
represent the state of UP. We are here today because after the tragic stampede in Baki Bihari Temple in August 2022, where people lost their lives in High Court, asked state to take steps to avoid such incidents in future. So the redevelopment project was started only for public safety. We are not changing any religious activities, Lordship. The temple religious activities will remain the same. We are only improving the basic facilities which are essential for the future needs so that devotee can have a safe and peaceful darshan. The project is not against the constitution. Does not violate anyone's right under Article 25 and 26. Instead, it supports Article 21, which guarantees the right to life and safety. We will show that this project is needed, it is planned properly, and is in the best interest of the public, Lordship. If my lordship permit, may I state the issue 1 and 2 much this issue?
Yes, yes. Please go ahead.
Yes, lordship. Lordship, kindly see page number 18 of my memorandum, TC-88.
Yes.
Lordship, this is a chart which I have elaborated from the, my lordship, this chart demonstrates the actual volunteer of devotee visiting Baki Bihari temple daily and during festival. Based on these verified records from the temple authority, it shows preservation existing narrow lanes, alleys and circulation paths. Here, lordship, this temple is covered with the parikrama which has come from the Prem Mandir to the Govinda temple to the Yamuna river, which goes from the circumambulation ways. Like this is the religious activity which they call as their sacred present. But lordship, in this chart you may see the people visiting on Saturday and Sunday mostly on the regular basis, but on the public on festival days are the more than lakhs. If you see, lordship, we submit this to illustrate the context for the redevelopment project, not to dictate policy, merely to provide conceptual grounding for the state planning consideration, lordship. If lordship may permit, I want to share one project idea, if my lordship may permit.
Yeah, please do.
Yes, lordship, obviously.
But please confine to the time limit.
Lordship, may kindly see Baki Bihari temple. Was it old, was this new project? Lordship, this old project was built in 1200 square feet meter, which they are saying that they can add alternative changes and can remap this temple. But there is difference between the remap the temple and redevelopment of this project. Here they are saying in 1200 square feet meter, they can add the single entry, exit entry gate. They can add the another stampede provision. They can add staggered darshan token system, but this will not decrease in crowd management, lordship. This will not decrease the crowd. This will not give the successful in the future for the stampede, lordship. But here we are creating this project so main entry, exit entry, which will not gather the people at a single place. We will build disabled women and other women for the restrooms, queues, other facilities. Like we can create a VIP darshan for the people who are like celebrities, actors, media who are coming. We can create a different line for the disabled women. We are creating the police post at the center. Like lordship, this is not the case where only we are thinking about the public safety and management. We are thinking about the future as well as lordship, because we don't know what circumstances will become in the future. Like in 2002 Akshardham case, where the terrorist attacks to the temple without who are only provoking terror. So, lordship, I have created the alternative risk for the project, which shows if terrorists attack on the temple, how it will implement. Lordship, this is the project where in our temple we will provide alerted lights. We will provide alternative options for the terrorist attack as well, because today the temple, which is built in 1200 square feet, is the walls are very long that they cannot be exit. when this type of incident will happen, Lordship. So we will create this type of project, will be show a more space which will not gather a person, devotees, pilgrims at a one place, Lordship. This will decrease in the sun pit and will give a more better future successful project in the Lordship. And Lordship, they are talking about their parikramas which we are affecting, which the violates Article 25 and 26. Lordship, this is the map of the Baki Bihari Ji temple currently, which shows parikrama marks comes from here. The purple line shows parikrama mark, Lordship, which goes from the Govind Dev Ji temple to the Prem Mandir to the Baki Bihari temple and to the last Yamuna river. At end, the where parikrama ends, Lordship. This shows, Lordship, that this project is not affecting, not violating any violation of the constitution, Lordship, because the Baki Bihari Ji temple is here, Lordship, you can see, and this is not in covered under the 100 meter. This is above 100 meters, Lordship, prohibited. This does not come under the prohibited area. If my Lordship is satisfied, may I move to the another issue?
But all these monuments, Shaji Temple and this, you just go back to this, and Madan Mohan Temple, these are not the protected monuments according to you.
So pardon, Lordship, I'm not able to hear.
Am I audible to you?
Yes, Lordship, yes.
In your this map which you had shown,
Yes, Lordship.
there was a Shaji Temple and there was a Madan Mohan Temple, something called that. So are they also protected monuments or they are not protected monuments?
Lordship, every temple is protected monument because they come
Every
under
temple
the
is a
heritage.
protected monument.
Like Kashi Vishwanath temple, like Jagannath temple. I'm talking
Ma'am,
about
I
those
am talking
temples.
about these two temples in this Parikrama area. Are they protected monument under the Act?
Which temples, Lordship?
Just show me that slide which you had shown once again. Show me that. Anyway, what is your argument to counter the argument on the petitioner side that there are protected monuments within the 100-meter limit and you cannot therefore demolish those monuments, or you cannot raise a construction within 100 meters of those protected monuments? What is the rebuttal to that?
Lordship, my rebuttal is there. Like, we are redeveloping our temple because there is lack, because this temple is only 1200 square feet, Lordship. We cannot alter the changes till there will be a crowd, gather people, because there is only single entry, Lordship. The people come from there and goes out from there. If we will add exit entry also, it will remain the same. People will come, devotees will get crowd management. If not proper, Lordship, we will add alternative changes like.
All right. Come to the second point.
Now other issues will be dealt with my co-counsel, Lordship.
Yes. Ma'am, you are not audible.
Am I audible?
Yes, a little better.
You're not audible. TC-88 speaker to you are completely not audible. Just adjust your meeting and then rejoin.
Lordship, still she is coming. I want to explain another point, if my Lordship permits. Lordship, they have stated that there is a executive order which they are saying that we have crossed the third process. Lordship, executive itself means to start or begin the project. The stage to start and begin, we have not consulted any authorities till now. They are saying that we have not taken consent from anything, any industry like ASI, any EI. Lordship. So we are saying that, Lordship, we are in the executive process. We are now starting. Yes, Lordship.
Yes, ma'am, yes.
Greetings to the bench. May I please to the Honorable Court heard my sister counsel. I shall address the next issue.
Yeah, please do.
The third issue is safety.
There seems to be some problem with your audio. There seems to be some problem with your audio, ma'am.
I think you're having a poor connection. What I suggest, switch off your video. That might improve it.
You can switch off your video as Mr. Sondhi suggested.
It might improve.
Just switch off your video. Just keep your audio on. Yes. Ma'am, unmute yourself.
TC-88 speaker to please unmute yourself.
Go ahead, go ahead.
Sir, can you hear me? Your
Yes.
Lordship?
Yeah, please.
I apologize for that issue. May I continue?
Yeah, please do.
Whether the state objectives of crowd management and public safety justify large-scale demolition and redesign of an organically evolved sacred precinct when less restrictive alternatives, strategic versions, tech-enabled flow, festival time regulation may exist. May I seek permission from the honorable bench to state the arguments?
Try to understand one thing. When you appear for the respondent, then you have only two objectives. One, to meet the case set up by the petitioner. That is one. That is your primary objective. Second, if there is any particular defense, all right, in addition to what the petitioner has not stated, but you have a defense against the case of the petitioner, then you can point out that. So instead of going into all these nitty-gritties of what you have prepared, you just confine yourself to three issues. They have raised three issues. One, that there are monuments, protected monuments, and you are carrying out demolitions within 100 meters of that. Correct? Two, that they have said that there is a ecologically sensitive Yamuna floodplain. So there is a violation of Air, Water and Soil Protection Act, and therefore you have to take care of that. And since there is a violation of that, so your act is questionable. Third, they have said that you have not undertaken any consultation as is mandated under Section 5 of the Right to Fair Compensation Act. So you have to first answer these three questions before you go any further. So take the medium and answer.
Yes, my lordship. So the first issue, according to my script, my first issue is the issue 3, when they are asking that large-scale demolition can justify or not.
Yes.
So in that issue, I can say that the first argument of mine is why temporary measures are not enough. Because currently the crowd management system is not fulfilling the needs of the temple. And the other thing is crowd surge is too big. On normal days, 40 to 50,000 people visit. On festivals, up to 5 lakh per day. People are visiting in that. So token system, barricades and staged darshan collapses under crowd pressure and emotional surges. The 2022 Baki Bihari stampede occurred despite police and barricades. So we can't say that the small or alternative objectives can fulfill our need or protects the next staged darshan. Stampedes, they can protect. We need a new redevelopment project, or we have to demolish this old one. And the second one issue is whether the absence of or inadequacy of meaningful public
Unfortunately, you're not audible.
again.
Ma'am, you switch off your video and just keep yourself unmuted. Unmute yourself now.
My lordship, can you hear me now?
Yes, yes.
So for this issue, I can say that Article 14 forbids arbitrary class legislation but allows regional classification if two conditions are met. First condition is there is a clear and logical basis, intangible differentia, the treat groups differently. And second, the difference is related reasonable to law's objective rational nexus. Here, shopkeepers and residents face relocation inconvenience, while pilgrims face greater safety risk. The valid distinction and the project's goal of protecting public safety satisfy Article 14's test by prioritizing public interest over limited private inconvenience. The corridor project consultation focuses on public safety and welfare, not personal profit. The state provides full compensation and rehabilitation to the shopkeepers' families and ensures preservation of religious heritage. Uh, the project improves aesthetics, safety, and crowd management without harming heritage. Consultations inform stakeholders, but individual interests cannot outweigh the safety of lakhs of pilgrims. The project does not violate Article 14, which forbids arbitrary state action but doesn't require mass consultation. Courts uphold policies that are fair, reasonable, and rational. Meaningful consultation occurred with experts like Archaeological Surveys of India, police, and temple trustees. Article 14 demands fairness, not perfect procedure, and consultation prove non arbitrariness. Urgent public safety needs justified limited consultation to prevent further stampedes and loss of life, prioritizing public welfare. Judicial precedents like Rajiv Suri versus Delhi Development Authority uphold expert based projects despite limited public participation as long as the policy is rational and non arbitrary. Public interest outweighs individual inconvenience. Relocation is compensated, but lives cannot be restored. Article 14 permits prioritizing collective safety. Consultation continues with plans for business rehabilitation, traffic rerouting, and ongoing expert dialogue. In conclusion, I just want to say the project's discussion making is fair, evidence based, addresses urgent safety, and balances individual and public interest, thus, constitutionally valid under Article 14. If my lordship is satisfied, may I seek permission from the Honorable Court to state the prayer?
Yeah, please go ahead.
In light of the issues raised, arguments advanced, and authorities cited, the respondents pray before the Honorable Court that it be pleased to first dismiss the petition filed by the petitioners as not maintainable as they have failed to establish proper standing and cannot show any real violation of law or constitutional provision. Second, to uphold the decisions of the state in implementing the Vrindavan Corridor project, noting that all the actions, including consultation with residents, shopkeepers, religious authorities, and technical experts, have been carried out purely for public safety and convenience.
All right, ma'am, we have read it. Mr. Sondhi, should we give some time to the petitioner, 5 minutes for rejoinder, because they have not argued on the jurisdictional issue as to how 32 is maintainable.
Maintainable, absolutely, sir. We can do that.
Yes, petitioner, please satisfy how 32 is maintainable against a direction, against a mandamus issued by the High Court, though the respondent very conveniently has ignored this point. How the petition is maintainable?
Your Lordship, in the parties involved para, it is mentioned that Govindas approached the Honorable Court under Article 32 of the Constitution of India. Your Lordship, when there is a grievous violation of fundamental rights, Your Lordship, we can directly approach the Supreme Court, Your Lordship. So,
But just see your prayer one.
yes, Your Lordship.
You say dismiss the writ of mandamus issued by the High Court. So, can a direction by a constitutional court, assuming that it is wrong, it is questionable, can you say that it violates my fundamental rights? So 32 petition is maintainable in the Supreme Court against the direction of the High Court.
Your Lordship, against the High Court of the decision of the High Court, it is mentioned in the para 7 of the prepo is that they approach the court under special leave petition, Your Lordship.
But you have stated under Article 32, special leave petitions perhaps comes under a different article.
Your Lordship, against the direction of the High Court, Your Lordship, it is mentioned that you against the order of the High Court, we approach the Supreme Court under special leave petition, Your Lordship. We challenge the direction of
special leave petition is under which article, sir?
136, Your Lordship. 136 of the Constitution.
But you have invoked 32.
Your Lordship, it's only for the sake mentioned in the proposal that is parties involved, Your Lordship, to maintain that 32 is mentioned, Your Lordship.
So can you invoke 32 and 136 together?
Your Lordship, when there is a same question, same cause of action, same parties involved, Your Lordship, both can be merged.
You are in which year of law?
Third, Your Lordship.
So you must have read the Constitution by now.
Your Lordship,
Article 32 petition is what? It is original jurisdiction, appellate jurisdiction, or what? Which
original jurisdiction, Your Lordship.
So can you invoke original and appellate together?
No, Your Lordship, we cannot appeal it together. But in the propo itself, it is mentioned that parties involved under 32 and para 7, it is mentioned that they approach the Supreme Court under special leave petition, Your Lordship.
So what should we take? Should we take it under 32 or 136? Because parameters for both the petitions are entirely different.
Your Lordship, to challenge the High Court order, we can only go for Article 136, that is special leave petition, Your Lordship.
So once you have filed a writ petition, how do you convert it into 136? Is there any judgment wherein the court can convert a petition filed under a wrong provision of law? Is any one of you aware of that judgment?
Your Lordship, I'll quote a judgment where Supreme Court held both can be merged, Your Lordship.
Both can be merged. Show me that judgment. There is no such judgment, Mr. Pawan. But there is one judgment for all of you. You just note it down. There is a Pepsi Food
Indeed, Your Lordship.
Limited judgment by the Supreme Court, which says that if there is a petition maintainable under any particular provision of law, but the parties have wrongly mentioned a different provision of law, then court has the power to treat the petition filed under a wrong provision of law to treat that petition in a correct provision of law. All right. So that power, court can always treat your 32 petition into a petition under 136.
Indeed, Your
Lordship.
Number 2, a petition under 32 is not maintainable against a judicial order.
Indeed, Your Lordship.
Right? Now, one more question which I wanted to ask you. You have validly raised a point of protected monuments, but construction of a corridor involves demolition instead of construction.
Indeed, Lord.
So, if demolition is to be carried out and no monument is demolished, but a building which is within 100 meters of the monument is demolished, will that also be covered under the Act?
Your Lordship, before approaching that protected monuments, they should take the prior permission from the authority, Your Lordship.
But you have not stated which of the protected monument will be demolished.
Indeed, Your Lordship, we've cited the two temples, Your Lordship. That is the Radha Madan Mohan Temple and Sri Radha Vallabh Mandir, Your Lordship.
They both are protected monuments.
Indeed, Your Lordship.
And they are to be demolished.
You know, they should not be demolished, Your Lordship. They should be preserved.
The respondents
are they going to be
redesign of the same, Your Lordship.
Your Lordship, yes, Your Lordship. They are covered under the corridor project.
Corridor project, yes, Your Lordship.
No, but the plan which they have shown, they are not demolishing those two monuments.
They have not
I specifically asked.
They've ignored the same, Your Lordship.
Sorry?
They are not aware of the same, Your Lordship. The protected monuments involved in the corridor project. They have not cited this point, Your Lordship.
No, they have shown one, they have screen shared one plan wherein in violet color that corridors were shown. And on one side there was this Radha Mohan temple and that Shahji temple and other temple. So they are not demolishing it. That is going just close by. It is
Your
averting.
Lordship, even though they are not demolished under Section 20A of the Act, the prohibited area, no public work also should be conducted, Your Lordship. No infrastructure work should be conducted in that area, Your Lordship.
That's what I'm saying. What is protected? Construction is prohibited or demolition is prohibited.
Sir, construction is prohibited, Your Lordship.
So what is being constructed?
Your Lordship, corridor.
What is a corridor? Corridor is a space. You are creating a space. So
Your Lordship,
if they are laying the floor to walk or if they are laying the road for traffic, is that a construction?
Your Lordship, it is the construction not only includes raising up a building, Your Lordship. Construction also includes any modification in that place, Your Lordship.
Any modification will include them. Okay. Ajay, any question from you?
I think that's more than enough, sir.
Very well. Thank you so very much. I am very happy to see all of you performing. But you are future lawyers and I wish you good luck. Please confine yourself to when a petitioner is arguing, then you have to be vigilant and careful about the issue which you are raising. Correct? And when the respondent is arguing, that the first issue which the respondent must look at is the jurisdiction of the court. Number one. Number two, they must essentially answer the questions raised by the petitioner and then show any other defense if that is relevant. All right. The plan which you screen shared, that was really relevant to the issue, because that addresses, at least 3 of their arguments, that one plan and that bar chart, both. But you did not answer, the 3 questions specifically, in spite of my asking you again and again. So when you prepare your brief next time, just keep this in mind. All right?
And
If my
All of
lordship
you have
permits,
done very well.
lordship, if you permit, I want to state some points if you don't mind.
Yeah.
Lordship, I want to answer that 3 points which they argue in just precise manner, if you don't mind.
Just in 3 sentences.
Lordship,
only.
they have
In 3 sentences.
Lordship, they have stated that they will talking about demonstration or a construction, Lordship, but we are not saying that this project will start from nowadays only. We are demolishing from the today itself. Lordship, we have only High Court has given only state order to execute. Now state have authorities to take the consent from the other authorities to ask for the municipal corporation to how to develop this project, corridor project, how to take the steps after that. Now they are stating that they have not done the consent, they have not taken the consultation, they are violating our rights. But Lordship, we are not taking any violation of the rights of the Constitution. We are only saying that the High Courts have given an executive order, which means to start or begin. Execute itself says definition that to start or begin any administrative work. So state now have right to start any project, Lordship. That's what we are saying here. And they are talking about compensation, Lordship, when this project will begin. If, for example, they are earning today 300 to 500, or we can say like 1,000 to 1,500 per day. After redevelopment of this project, they will earn more than that, because this project is wide more bigger than the old one project, Lordship. So
All
that's
right,
my point, Lordship.
All right, ma'am.
And
Thank you very much, ma'am. Thank you.
Obvious,
Thank you
Lordship.
very much. Thank you, everybody.
thank you, everyone.
Thank you, sir.
Shivam, what do we need to do now?
Sir, the participants will wait outside the room, and after the discussion, you will announce the bench will announce.
Yeah, Mr. Pawan, for your legal arguments, out of 30, we both of us were unanimous, and we have evaluated you to the extent of giving you 26 marks out of 30.
Indeed, Your Lordship.
You argued well, and organization and presentation, we have given you 15 marks out of 20.
Indeed, Your Lordship.
And general evaluation is 10. Responsiveness to opponents is 5. And why we have evaluated you at 5 is because you also did not take care of what they are arguing, in spite of we giving you another opportunity by way of rejoinder. So you just keep that in mind. So, and responsiveness to the bench was 8 and delivery is 12. You have been good in delivering what your point of view, whatever you have prepared. So your total comes to 76. And your speaker number 2 is Miss, what's your good name, ma'am?
Rakshita, sir.
Miss Rachita, you got a little less time than Pawan, but you did better than him according to us, and we have evaluated you to the extent of 30 to 23 in legal arguments, but in presentation we have evaluated you at 17. And general evaluation is 11, then responsiveness is 5, 8, and delivery is 15 because you delivered faster than your colleague. So your total comes to 79. Correct? And team 2, ma'am, speaker 1, you are Miss, what's your good name, ma'am?
Varsa Somani, Lordship.
Sorry?
Varsa Somani.
Somani. Yeah, this is 21 for legal arguments, 12 for organization and presentation, 10 for general evaluation, 5 for responsiveness, 4 for responsiveness to judges. And you need to work in your next moot. Why we have given you 4? Because the questions which we put to you remained unanswered according to us, right? Because you were not perhaps prepared for those questions, though you tried hard in the end.
Lordship.
Anyway. And then 12 for delivery, so your total comes to 64. All right. And speaker 2, ma'am, what's your good name, please?
Devanshi Sharma.
Devanshi, we have evaluated you at 12. Sorry, this is 21, 10, 12, 6, 4, and 10. So your total comes to 63. So in our evaluation, team 41 wins in this semi-final. And best of luck to all of you. But I must share one thing that I enjoyed it a lot, and all of you worked very hard. So respondents really have a tougher job to do, but the indication which I had given to you, tomorrow you will be in real courts. So just keep in mind what the petitioner has argued. All right. So many times when we appear for the respondent, so our entire line of argument changes after we hear the petitioner, right? And then we first respond to them and then make our point. Okay. Best of luck to all of you. And thank you very much. Thank you, Ajay. Thank you so very much.
Thank you, sir.
Thank you, sir.
And
It was
just one
interesting
advice while watching, sir, see how simple sentences sir is using, and he's saying it from a third person perspective so that anyone and everyone can understand. Similarly, whenever you are addressing arguments, don't be in a rush. While you're in a rush, you forget a lot of things, and secondly, it does not come across nicely to anyone. That's something which we keep on learning, and that is something which you should learn and take a cue from what sir has just stated also.
Okay. Best of luck.
Nice.
Best of luck.
Thank you, Vanessa. Thank you, everyone.
Thank
You
you.
participants can leave the room.
Thank you.